Hi, so my name is Michaela, and I chose side B, which is states choose any states or speak generally do not have to suspend protecting human rights for security reasons. I believe that states do not have to suspend protecting human rights for security reasons. This is in part due to the hunger for control and power and use of the violent specialists that comes along with it. The rights and freedoms of the human person are never as fragile as in times of internal and international upheaval. When fending off emergencies, governments often decide to take measures that interfere, sometimes drastically, with such rights as the right to effective remedies for human rights violations, the right to privacy, the right to freedom of expression, association, and assembly, and the right to liberty and security, and the right to due process of law before an independent and impartial jury. Under the international human rights laws, independent and impartial courts must first be allowed to continue functioning freely during an emergency situation for the purpose of ensuring the effective protection of rights that can never in any circumstances be derogated from. Second, they must, at least under the International Covenant on Civil and Political Rights and the American Convention on Human Rights, remain competent to exercise control so that the derogatory measures do not exceed the limits of what is strictly required to deal with the emergency situation. Lastly, under all treaties, courts must be available to ensure that the rights are not derogated from, continue to be fully ensured in practice. The problem comes then in the form of governments exercising these state of exception, state of emergency, state of alarm, state of siege, issuing martial laws, and so forth. These exceptional situations often involve the introduction of special powers of arrest and detention, military tribunals, and, for instance, the enactment of criminal laws that are applied retroactively and limit the right to freedom of expression, association, and assembly. Worse, in many cases of upheaval, states have recourse to torture and other forms of ill treatment to extract confessions and may also, with or without the help of private or semi-private groups, resort to abduction and extrajudicial killings. Furthermore, the right to have recourse to domestic remedies such as the writ of habeas corpus may be suspended so that victims of arbitrary arrest and detention are left without legal protection and devastating results. This abusive use of extraordinary powers is not lawful under these aforementioned treaties. These treaties instead provide state parties with limited but flexible and well-balanced exceptional powers designed to restore a constitutional order to which human rights can again be fully ensured. However, in spite of their non-derogability, human rights such as the right to life and the right to freedom from torture and other forms of ill treatment are frequently violated. Moreover, as repeatedly noted with concern by the Human Rights Committee, the domestic law of the states parties to the International Covenant on Civil and Political Rights does not always meet the requirements of Article 4, Section A, and thus fails to provide absolute legal protection for some human rights in times of crisis. This can be shown in the Yalgan and others case, where two applicants submitted that their right to a fair hearing had been breached as a consequence of their conviction by the Ankara Martial Law Court, which lacked independence and impartiality. The European Court noted that the Martial Law Court had been set up to deal with offenses aimed at undermining the constitutional order and its democratic regime. However, it concluded that it was not its task to determine in abstracto whether it was necessary to set up such courts in a contracting state or to review the relevant practice, but to ascertain whether the manner in which one of them functioned infringed upon the applicant's right to a fair trial. The minimum guarantees for criminal trials prescribed in the International Covenant on Civil and Political Rights, the American Convention on Human Rights, and the European Convention on Human Rights prove an important, if insufficient, measuring tool for fair trial guarantees that should be applicable at all times, including in public emergencies threatening the life of the nation, universal and European levels, and the independence or security of the state, which is the Americas. In such situations, the foundation of human rights principles must be reinforced, and it is a responsibility of the legal professions to help ensure that this is in fact the case. Peace and security are best served by an even-handed administration of justice, also in times of adversity. It is a good lesson to keep in mind that at no time in history has too much justice and respect for an individual's rights and freedoms been harmful to national and international security, peace, and prosperity. In times of crisis, a concerted effort by all actors in society, including judges, prosecutors, and lawyers, to maintain the highest possible standards of human rights protection is not only more difficult, but also more necessary than ever to contribute to the restoration of a constitutional order in which human rights and fundamental freedoms can again be fully enjoyed by all.